15.
Of course, I'm going to go ahead and ask you real quick. And that was decaf, right? Yes.
Very much.
To a coffee shop, and he ordered a coffee specifically without caffeine because he was diabetic. They gave him the wrong coffee. They actually gave him one with caffeine, and what happened is that he ended up having a heart attack. In this moment, the customer, the employee would not be the one who is liable for it. It would actually be the company.
Basically, in this case, an employee acts as an agent of the principal. So an agent of the principal will represent the company, and the company is liable for any torts that happen within the premises. In this case, this previous case, the clerk would not be liable for lying about the caffeine because they're within the building of business, and the business will assume respondent superior, which means liability for your employee's action, and also vicarious liability, which means the company will back up any actions done by employees while representing the company.
Determining the scope of employment. These 8 factors that I am about to read are the ones that determine whether a particular act occurred within the course and scope of employment. The first is whether the employee's act was authorized by the employer. The second is the time, the place, and the purpose of the act. The third is whether the act was one commonly performed by employees on behalf of their employer. The fourth is the extent to which the employer's interest was advanced by the act. The fifth is the extent to which the private interests of the employee were involved. The sixth is whether the employer furnished the means or instrumentally, for example, a truck or a machine. The seventh is whether the employer had reason to know that the employee would do the act in question and whether the employee had ever done it before. And the last one is whether the act involved the commission of a serious crime.